Good day, everyone. I'd like to welcome you all this morning, and I truly appreciate and we thank you for taking the time, as we know everyone is extremely busy at this time. But we do believe that this is of real value to you and to all of us, and we hope that you will learn as much as we will learn from this. As the Institute for the Advancement of Journalism, we hereby would like to thank SANEF, the South African National Editors Forum, for the opportunity to partner on reporting the courts. As the IAJ, we believe this new version, the updated reporting the courts, is extremely important and crucial for especially young journalists to be exposed to and to understand how it operates. This book was first published in 2006, and SANEF has once again managed to find the funding and to update it. And we truly believe that this is a tool that will be used and should be put in a place where journalists will always be able to access it. This book we will do a series of 5 webinars, which will cover certain areas that has been published, but also what it will do is it will better support journalists and everyone that's interested in how the courts operate to know where and how different cases are heard. As the Institute, we believe that this 5 series of webinars is a brilliant way of introducing everyone to the updated version of reporting the courts. It stands to assist and especially prepare the reporters for better court coverage and to understand the functions of the different courts and what they do. I also think it will be important for journalists to monitor this quite closely when reporting the courts. Also to measure and see how long the courts actually take to deal with cases. Is there a huge overload? What can we as journalists report better on and propose for the system to work much better and more effectively? I now will hand you over to Hopewell Hadebe, the Projects and Office Manager of the South African National Editors Forum. Hopewell, over to you.
A very good morning, everyone. As my colleague Faz has said, my name is Hopewell Hadebe. We are really pleased that you are joining us today for the first of 5 seminars or webinars that we have planned for the training on reporting the courts. Just a quick glance of where we come from with this project. It was actually a master's program that was done for Kevin Ritchie, who has since been moved on. He was the editor for the Diamond Field advertiser, and then he moved to Johannesburg, started with the Independent and went on to be with the Saturday Star before branching on to law. And so SANEF liked the work he had done so much that there was a lot of discussions of how we can make this a booklet of sorts, a pocket booklet actually for journalists. And then we moved on and asked Gwen Ansel to put it all together and do away with legalese and make it friendlier for the media. And we ended up publishing over 1,000 copies, maybe even 3,000, and sent them around the country. They became almost a guide for most media houses, a guide for many journalists and news editors, and also a guide that for training that you find in many universities and colleges that deal with journalism. We then, it was even a project that was liked so much that the Magistrate Commission enjoyed looking at it. The Justice Pius Langa, the late, wrote the foreword for us, and he really enjoyed looking at how we were putting together something that will assist in making journalists understand the way the system of the law will work in South Africa. But 10 years later, we felt we need to really update it because some of the laws had changed. Most of those laws had moved, and even the systems of the court had evolved. So we then managed to find funding from the Open Society Foundation, and we then called Gwen back to look at it. Fortunately, she was available to do that. She worked with a researcher for LLB. Her name is Nkuli Sipambato. They did a stunning work looking at all the laws and putting it together. You'll recall that there's been now a norm in South Africa to have commissions of inquiry, and there will be one of the webinars that will look into this, how we are reporting on commissions of inquiry and what they mean in our legal system. And so this time around, we were able to even get Justice Yvonne Mohoro to do the forward for us. So we know that this is a document that she looked at and thoroughly and was very impressed with the way Gwen and the colleague have dealt with this. So you are getting a very fresh, a revised manual, so to speak, or booklet, and we hope to republish this and send it to many newsrooms also. So you are privileged, together with all of us, to be getting the most updated information here. And I'll take back to IAJ to kind of go ahead with the process. We welcome you and we thank you so much for participating.
Thank you, Hopewell.
Thank you so much, Hopewell. Thank you.
That was a brilliant introduction, furthermore to the book. And I think this will especially interest the journalists far more to understand what is happening. Not to waste any more time, I will hand you over now to the capable hands and the brilliant experience of the two facilitators who you will be introduced to today and who will take you through the 5 series. That is Dianne Walker and Candice Bailey. I hand over to you both.
Good morning, everyone, and thank you to Hopewell and Pfizer for those introductions. I am very happy to be partaking in this webinar series along with Candice Bailey. Just a little bit of a background about myself. I have been a court reporter and sort of a legal specialist reporter for a number of years now. I started my career at the Cape Argus many moons ago, where I was the High Court reporter. And since then, even though I've gone on to cover other types of topics, I've always remained with a passion for legal reporting. I think it is a very important aspect of our work covering a fledgling democracy. You know, there is quite a lot of focus on political reporting, but at the end of the day, a lot of that politics tends to end up in the courtroom space. And we're hoping that through this webinar series, we'll be able to take you from the basic level of understanding, which is where we are starting today, to a much more nuanced level of understanding where we hope to be on webinar 5, looking at the various issues, starting with just an understanding of the legal system, the South African legal system and how it works, and edging all the way up to focusing on the judiciary as well as reporting on vulnerable groups in some of our later sessions.
Thanks so much, Dianne. Good afternoon and good morning, everybody. My name is Candice Bailey. I am a journalist in South Africa. I've been on the other side of Dianne. I've been a crime and investigative reporter, and I've also had to deal with the court system for many years. For the last 5 years, I've been working at The Conversation Africa, not covering court as much, but still keeping a close eye on what happens in the legal system of South Africa. So, guys, without further ado, I'm going to move on to our program, just to outline exactly what we're going to be covering in our session today. We've had the welcome from SANEF. We're going to walk through some of the objectives of the webinar, just and what we want to achieve today. Mostly the webinar, there'll be 4 parts to the webinar. We'll look at the Constitution, the Bill of Rights, and the rule of law. We'll discuss the hierarchy of the court system. And then we'll talk a bit about the main challenges that we face as journalists covering the court and what we should be thinking about, what the role of the media is in terms of the court. And then we'll have some closing of remarks from SANEF. I'm going to hand over back to Dianne, and she's going to take you through the first part of the session. I hope you enjoy your time with us today. And just some house rules before I get going, Dianne. We're going to ask everybody to keep their videos off, just so that people don't get distracted by your video. We're also going to ask you to keep on mute. We will have a question and answer session at the end of our presentation. So if you do have any questions, please feel free to pop them into the chat box, into the the Q&A box, and we'll note them until that time of the webinar. If you are able to tweet and you want to tweet the session, please feel free to go ahead and tweet. The hashtag that we have for the session today is #reportingthecourts. So if you do want to let people know that you're part of this webinar series today, please feel free to tweet #reportingthecourts. And without further ado, Dianne, over to you. Thank you.
Thank you, Candice, and thank you for those ground rules. So in terms of the objectives that we want to do is, this particular portion of the webinar series is really to get an understanding for those of you who haven't really engaged that much with the legal system. We realize that there are a lot of stories that now enter the legal space, whether it be entertainment, even from a sporting perspective. There are points where the legal system interacts with almost every aspect of our lived experience. And we're finding that it's not only specialist legal reporters that have to actually engage with the legal system, but in fact, all journalists from all backgrounds. So we want to provide a good overview of the South African legal system, as well as an introduction to the Constitution and how important it is to actually understanding the legal system. And then we'll take you through a little bit of a breakdown of the criminal and the civil law aspects, and of course, understanding the role of the media. And then we'll also just give you a bit of a foregrounding as to what is to come next in this webinar series. All right, so if we can move on to the next slide. So I found this quote, which I found quite powerful, talking about our role in a democracy. The former President Nelson Mandela is often credited as the father of our democracy. He's spoken about how our diversity isn't actually what divides us, but the thing that can really bring us together is to achieve our freedom and also to have a good understanding and cherish our democracy. And one of the key aspects of us being able to do that is to really engage effectively with our Constitution, both as citizens, but also as journalists, because it really is the main grounding point for understanding our legal system. Now, if we start looking at the Constitution, the Bill of Rights is one of the main areas that we engage with as journalists when it comes to the Constitution. It's not the only important part, but it is a key aspect of both reporting on the law, but also reporting on rights in general. The Bill of Rights, which is in Chapter 2 of the Constitution, it deals with the rights of citizens quite broadly. And we actually see it play out in so many instances when it comes to court cases that end up entering the legal sphere. Just a recent example has been the issue about the vaccine mandate, which we've seen a lot of reporting about this recently. There are a number of legal challenges that have been threatened, and one that is currently underway being brought by the ACDP. And really, it comes down to a rights issue. In that court case, they're looking at the rights of children, rights to healthcare, and to an extent, the rights of freedom of security of a person. And all of those rights are contained in the South African Bill of Rights. So just looking at that one court case, you can actually see that the Bill of Rights tends to go into various aspects of our lives, as well as various aspects of reporting. There are many times where people will say, well, this is not constitutional. And I think it's important for us as journalists to be able to engage with the Constitution to actually find out what it allows and what it disallows, as well as the things that it puts in place that speak to other aspects of law. The Constitution also deals with the structure of government. And that's very important, particularly for those of us who might be reporting from a political perspective. We saw aspects of this in the recent local government election, where the aspects of the local government election all find their root in the Constitution. How the government should unfold, when elections should take place, how mayors should be elected. All of that is contained in the Constitution. And even when you look at something like a recent story that we saw where Job Mokgoro, for example, was removed as the Northwest Premier, there was a lot of misreporting on that incident, because after he was removed, Bushi Mabe was named by the ANC as the new Premier. And in fact, he wasn't the new Premier because in terms of the Constitution, that part of the process hadn't actually taken place yet. He hadn't been sworn in by the legislature. He wasn't even a member of the legislature at that point. So he couldn't possibly have been the Premier as required by the Constitution. So the Constitution gives us as journalists an opportunity at times to even fact check some of the misinformation that is being put forward by members of political parties who make outlandish claims at times, and without them actually referring back to our founding document. Government finance is also something that is laid out in Chapter 13 of the Constitution. And in terms of the part that is actually quite important to us when it comes to journalists, is that the Constitution requires that the budgetary process must promote transparency and accountability and effective financial management of the economy, debt, and the public sector. And that's found under Chapter 13 of the Constitution. So if you think of what we saw yesterday, the Auditor General releasing financial reports, and we consider whether there really is transparency and accountability, one has to wonder whether government departments are acting in terms of the Constitution when it comes to the way that they manage their finances. And that in itself could prove to be a story that we take forward, looking at how governments are actually handling their finances and what's required by the Constitution. Now, looking further, other aspects of the Constitution that we find coming up regularly within the court reporting as well as in general reporting on the legal system, the recognition and the role of traditional leaders. Now, that might seem like something that doesn't necessarily affect us that much, but if you consider what's taking place now with the issues surrounding the Zulu Kingdom, for example, that actually takes us back to the issue of traditional leaders as enshrined in Chapter 12 of the Constitution. This is one of the sections of the Constitution which isn't particularly long, but what it does do is it calls for there to be national legislation that actually spells out the role of traditional leaders. And we see that national legislation in the Traditional Leadership and Governance Framework Act, which is actually the legislation that is at the core of that legal challenge. But all of it ultimately leads us back to the Constitution. When we look at security services, for example, the Constitution actually goes into quite a lot of detail about the defense force and how it should be managed, as well as the police service. For example, it says that the national security should reflect the resolve of South Africans as individuals and as a nation, to live as equals, to live in peace and harmony, to be free from fear and want, and to seek a better life. And then it goes on to further clarify how the police service should be set out. For example, it indicates that there should be a national police commissioner, and there should be a member of the executive that is responsible for policing. It also indicates that there should be a member of the executive that should be responsible for the security services, for the military. An interesting thing within the Constitution that I actually noticed in preparation for this webinar is it also sets out the situation as it refers to intelligence services. Within that chapter of the Constitution, it speaks about that the president should either delegate the responsibility of overseeing intelligence services or actually take on that responsibility him or herself. And if you recall recently with the most recent cabinet reshuffle, we actually saw the intelligence services moving from being at a government department or being with a minister who's in charge of that to being placed within the presidency. And there were a lot of questions about that and whether that's actually constitutionally allowed. But incidentally, the Constitution actually does give the president that power to be able to hold the security services within the presidency and have direct oversight. So again, you can see that the issues that are set out in the Constitution are issues that we deal with on a regular basis as journalists. And of course, there's the aspect of the courts and the administration of justice. And that is one of, I think, the most detailed aspects of the Constitution, because it really sets out much of our legal system. It explains how the courts should be set up from the point of magistrates' courts to High Court, to Supreme Court of Appeal and Constitutional Court. And just for those of you who want to know whether we'll be dealing with this later, in the second part of our webinar series, we will go into much more detail about that hierarchical system of the different courts. It also deals with the terms of service for judges, for example, the appointment process for judges, which actually has become quite an interesting and very closely watched part of our democratic process recently. This is because the Judicial Service Commission has started making those hearings much more publicly available by posting them online, but also because the actual appointment of judges has become, in a way, also part of the political process, with political role players taking a keen interest in how judges are appointed. And of course, we've seen now that it can be quite a tense process being followed with very, very intensive questioning, particularly when it comes to the appointment of constitutional court judges. So Chapter 8 of the Constitution really sets out those details as to how judges can be appointed, but also it specifies to a certain extent how judges can be removed, and it calls on government to create legislation, which we see in the Judicial Service Commission Act, that further explains the process in detail. And in fact, that process is what we're seeing unfold at the moment with relation to Judge John Hlophe, who is currently in the process of going through an impeachment process. All right, so obviously quite a complicated legal system that we're dealing with here in South Africa, a legal system that has had to change over time. And what we find ourselves dealing with at the moment is an amalgamation of Roman Dutch law, English law, as well as common and customary law. Now, the Roman Dutch law, to the large extent, comes from the fact that that we were initially colonized by Dutch settlers who came along with Jan van Riebeeck and brought much of their legislation with them. And later on, the English took over South Africa when it was still a colony, and they made their own amendments along the way. Some of those amendments we actually still see to this day. I mean, if you look at the way that our advocates dress when attending court proceedings, they wear those long black robes, which are certainly not suited for South Africa's climate. But that's really an aspect of the origins of English law. And then, of course, we have common law and customary law. And common law and customary law are more practices that we've come to accept as people, and also customary law is a bit more specific to sort of customs that have been experienced over time here on the African continent and within the South African context. A lot of it passed down verbally as opposed to being written. But what we are seeing now is aspects of that customary law being incorporated into legislation and being incorporated into the laws that we have in the country. One example of that is looking at how the marital law has actually been amended over time in South Africa. And it is now possible to be married within customary law within the South African context, which was something that was not widely accepted and legally accepted in the past. And this has actually allowed for there to be safer provisions, for example, for women who are involved in a customary marriage, so that their husbands can't, marry someone through the sort of, I don't want to say legal process because they're both legal, but marry someone through the civil law process, and then later on marry them through the customary process, and then they lose property rights. And the courts have over time clarified that there needs to be a recognition for customary law, particularly to allow women who are married through that process to have access to inheritance and to ensure that they also don't lose rights that other people would have through civil marriage processes. We can move to the next one. So as I mentioned, the Constitution is really the main grounding of the South African legal system. And it's one of the main ways in which law is formulated, because the Constitution throughout it will actually indicate that there needs to be law created to uphold a particular provision. And that's really because the Constitution, you can consider it more as sort of a blueprint. It's a grounding document. So it creates the initial sort of bedrock on which our legal system is built on, but it also acknowledges that it can't contain everything, and it requires the government to then specify further how things should unfold. And that's where we get statutes or legislation. Now, Parliament is mainly responsible for ensuring that this legislative process continues. And Parliament is constantly undergoing the process of creating and amending new laws. But the important thing is that those laws must always be in conjunction with the Constitution. And we do see oftentimes where perhaps Parliament has made a law that isn't in line with the Constitution. That then goes through the court process, and the court can request that that law is changed in a particular way to make it more in line with the Constitution. Now, a recent example of that, if you consider the recent elections that we had, for example, where there was previous legislation that had to deal with the IEC and how they run elections, but there were questions raised about whether political parties should be more open in terms of the Constitution about declaring the funding that they receive. And the Constitutional Court ultimately ruled that political parties must declare the funding that they receive above a particular threshold. And now we actually see the IEC releasing quarterly reports in which they are reporting to the public on where and how much, where the funding comes from and how much the funding is that political parties are receiving. So in that case, you can actually see a very direct link between the Constitution, the creation and amendment of statutes, legislation. And then when it comes to customary law, like I said, that those are common practices that have been passed down through generations, but that ultimately do become part of law. And of course, the customary marriage provisions are an example of just such a thing. And the difficulty with customary law, of course, is that customs are not the same throughout the country. So oftentimes the courts have to unravel and go back in time to a certain extent, looking at what was the custom or is the custom in a particular group of people. So if we look at the situation regarding the Zulu King, for example, while the legislation around the appointment of as Zulu Kings is something that has been passed down over generation, the question will be whether the process that was undertaken by naming Mrs. Zuluka as the king in this instance was first of all done within the customary law as it's understood by the Zulu nation, whether it's done in a constitutional process, and also whether it's done in line with the existing legislation. And there might also be a need for the courts to clarify how all of those things fit together, because there is this dispute over how this should work, partly because customary law is one of those things that largely relies on memory, as well as kind of written or spoken information that's passed down from generation to generation. Now, when it comes to legal precedent, that's something that we also see as a source of law, where judgments actually create law by clarifying the understanding of a particular provision and clarifying the interpretation. And this is because sometimes the wording of law isn't always 100% clear. The Constitution, I believe, does try its best to kind of clarify things, but there are instances where there's a question as to when it says will or must. What does it mean? When the Constitution says that a particular process should be followed, what does that actually mean? And we often see that unfolding, for example, when the government is taken to court and there's a need for clarification on what is required from government. One of the cases that I think many of you might have heard about is the Grootboom case. And that really it speaks about government's requirements when it comes to the provision of housing. What is government actually required to do? And the Constitutional Court was able to actually create that case as legal precedent to actually spell out what government is actually required to do when it comes to the provision of housing, that they actually need to make housing available for those that are indigent in society, as well as to create the circumstances for people to also be able to create their own housing. And that case has served as legal precedent for many, many other cases relating to housing that we've seen unfolding over the years, where government perhaps is saying that it can't create housing. Then you'll see, the Grootboom case being referenced in relation to that, because it is seen as sort of the main case when it comes to housing issues. All right, we can move to the next one. One other important thing to consider about the current South African legal system is that it is a system that is meant to focus not on restorative justice. And Candice will take you through this a little bit more in the next section as to why that is important. But it's a difference in the way of thinking as compared to the legal system pre-democracy. The idea is really that the process of justice is not something that is only held by the courts or by the parliamentary process, but it's actually that we are all custodians and involved in the legal system. And the process of if someone is sent to jail or is found guilty for crime is not only to kind of give the harshest punishment available possible, but integrated into society. And that's why it's considered a restorative justice process. We see this, for example, in the process of people being given parole, where they are actually allowed in certain instances to engage with the family members of those that they might have wronged, even if they have murdered someone, that they can ask for that opportunity of penance and explain why they are deserving of parole. One high-profile case that I can think of in which we are seeing this unfold as we speak is actually the Oscar Pistorius trial, where we've seen recent media reports where Oscar Pistorius has been moved closer to the family of Reeva Steenkamp, partly so that he can actually speak to them and express his sort of have his apology to them, but also it's part of that restorative justice system where the South African system doesn't want to lock people away and throw away the key, but sees even offenders as people that can be reintegrated into society, either by performing community service while they are on parole, by getting the input of those that they have wronged during the parole process, or by just being, model prisoners while they are in jail. And even sometimes by not sending people to jail, if it is the best process, if the crime doesn't actually warrant incarceration, the justice system does allow for that in thinking of it as a restorative process. I hand over to you now, Candice.
Thank you so much, Dianne. Dianne's given us a wonderful overview of the legal system, the Constitution, and how it all comes together. Before I move on to my section, I just want to check that we all are still around. Does anybody have any questions that you want us to field at this point? We hadn't put a question slide in, but there may be one or two questions that you want us to. We just want to see that you are still alive and listening to our session. No questions, it seems. We're going to move on. So now that Dianne's given us this, Liesel, do you have a question? No. Looks like you don't.
No, I was just saying I am still listening and I'm still alive and enjoying it. Thank you.
Perfect, perfect. Thank you so much. It's lovely to see that you have people that you're talking to and you're not talking to yourself. So thank you, Liesl. So Diane's given us a good idea of the Constitution, how it's broken down, and how we find the sources of the law, as she put it. And I think she's done a great job. Thank you so much, Dianne. The one thing that I want to touch on is rule of law versus rule by law. So rule of law is a foundational value of our current constitution. And it's important to note that, let's start with rule by law and how rule by law works. If we had to define rule by law, it's really when governments use the law as tools of oppression and tools of repression. They don't enforce the law equally across society, and it means that some people are either advantaged or disadvantaged by the law. Apartheid is obviously a clear example of rule by law, where we saw more than 200 laws being effected in a way that really disadvantaged large parts of our society for a long part, for many years, for many decades, in fact. And apartheid is obviously not the only instance of rule by law. You also see it in Nazi Germany in the 40s, where there were also laws where Jews were then placed into concentration camps and also were disadvantaged by the system. Obviously, apartheid is one of the big examples of rule by law. But in contrast, what we're seeing now in democratic South Africa since 1994 is rule of law. And that's really when the system has been created so that power is distributed evenly across society. Everybody is equal before the law. And that's really important because it means that it's everybody from the president to an ordinary citizen faces the same types of accountability. And obviously the president has different types of questions to answer, but we all are accountable before the law. And that's an important aspect of our constitution and of our legal system, that we are all equal before the law. It's based on a culture of justification rather than a culture of coercion and fear that we saw during apartheid. Check the questions. My volume is a bit low. Thank you, Hopewell. I'm hoping my volume will get better. I'll speak a little bit louder, Hopewell. Thank you very much for notifying me. In addition to, so when we look at rule of law, which is what we are currently experiencing in South Africa, and we're talking about distributing power evenly across society, how does government ensure that that happens? How do they make sure that the power is distributed across society? We do that through a special doctrine that we find in the Constitution called the Separation of Powers Doctrine. And what the Separation of Powers Doctrine talks to is the fact that the state divides power across the three different arms of government. And Dianne touched on this slightly, so I'm not going to get into too much detail, but just to explain how the different elements, the different arms of the law speak to each, or the different arms of government, pardon me, speak to each other. I'm just going to give you a few points under each of these arms. So on the one hand, and Dianne spoke about this, you have the legislature, and the legislature makes the laws. And then you have the executive, and what the executive does is that they administer the laws that have been made by the legislature. The third arm of government, and that's particularly relevant for our session today, is the judiciary, and the judiciary interprets the law. So in our legislature, we have the National Assembly and we have the National Council of Provinces. And those two houses have very distinct functions and powers that have been set about in the Constitution, as Dianne mentioned. The National Assembly is primarily the National Assembly is primarily, is my sound a bit better? I'm hoping my sound is better.
I think
I
it's
don't
better. There was a slight scratching sound, but it's gone now. So I think just, yeah.
I hope so. Thank you. Thank you so much. The National Assembly is primarily tasked with appointing the president, choosing the president, passing laws, and ensuring that members of the executive perform their functions. The National Council of Provinces is particularly a forum that debates on issues that affect provinces. They also have a responsibility in terms of making law. Thanks so much, Hopewell. But primarily, they are involved in providing the provincial perspective in terms of this scenario. when it comes to the executive, the president is the head of state and the head of the national executive. You'll often hear we've heard it many times over the past 22 months with COVID, that the national executive is meeting to discuss various issues. And that's obviously the national executive. It's been the president meeting the ministers, the deputy ministers, and the members of cabinet, and they then make decisions. What the national executive does, to highlight what I said earlier, is that they administer the laws. So the legislature makes the laws, the national executive administers the laws using policies. So they develop various policies that speak to how those laws can be administered and enforced and properly enforced in our country. The judiciary, a very important part of today. And like Dianne said, we are in session 2 of our webinar. We'll get particularly into the judiciary and the courts and how the courts work. But just to give you a little bit of a picture, if you can imagine a 5-story house, that is what the judiciary is. It's made up of 5 sets of courts, essentially, and we're starting off on the lowest level, at the door, at the entrance level, we're starting off with the magistrates court. Magistrates courts above the 2nd level, floor 2 of the house, we're sitting at regional courts. From regional courts, we get to high courts. High courts take us to the Supreme Court of Appeal. And after the Supreme Court of Appeal, we sit with the Constitutional Court. Now, the Constitutional Court, since the Constitution is the most supreme law in our land, the Constitutional Court is also the most supreme court in our judicial system. What the Constitutional Court does is it deliberates over issues of it interprets matters of constitutional affairs, and when people have constitutional challenges. We saw it recently with Jacob Zuma's application to the Constitutional Court to have his decision, to have his judgment around his contempt of court case rescinded. So that was a Constitutional Court matter. He was saying that it was going against his constitutional right as a citizen. There are many other cases that get seen before the Constitutional Court, but for ease of time, in fact, I'm not going to go through the different courts and what they do, but I am going to talk about the differences between criminal law and civil law. And I think that that's really important for us in this overview session, is to help you understand as a journalist how criminal law and civil law work together in terms of the South African legal system. So by now you've figured out that the South African law system, legal system, is divided into criminal law and civil law. And the main difference between these two types of law is really that there's differences in the way the crimes are defined, the procedures that the courts have to follow, how the proof of burden, the proof of the crime is determined, and also the types of penalties that these crimes impose. I'm going to start with criminal law because it's a little bit, we see criminal law often, we often see it reported in our media. In fact, we see civil law as well, but sometimes we don't recognize it. Criminal law, let's give you some examples of criminal law. Rape, murder, abduction, fraud, housebreaking, indecent assault, public violence, robbery, theft, corruption, kidnapping, forgery. These are some of the cases that can be imposed on people in the criminal law system. The main difference with criminal law to civil law is that it imposes a punishment as opposed to civil law, which offers a redress. So when you're looking at the civil law, often a civil law is trying to fix a problem. So there is a contract that's been, it's back to my notes. It's when a person or an entity which is called a plaintiff in most instances, or complainant, they are trying to get a redress around a specific issue. So let's look at some examples of civil law cases. You could have contract disputes. So somebody owes you 20,000 Rand and they haven't given you, that would be a civil case that when you go and claim that money from them. Personal injury disputes, like the road accident fund, that's also it's a personal injury dispute. It's also something that will be a civil case. Class action suits. We've seen many of them in South Africa. Two of the most prominent that I can think of is the silicosis case, and that's where the gold miners, which is a long-running case, it's set a precedent, in fact, but gold miners were given compensation for developing silicosis and TB while working in the mine between the 80s and the 90s and the 2000s. Another class action suit that we've seen is the listeriosis case. I don't think it's come to fruition yet, but a few years ago, I think it was in 2016, We had our polonies and our cold meats that were affected by the listeriosis bug. Well, I don't want to say virus, and we then saw lots of people get ill and some people even die, and they've been able to launch a class action suit in that instance. Divorces are also civil cases. We also have defamation, that's civil cases, and as journalists we often face cases of defamation. Most often it doesn't go to court, but there are instances where they have gone to court. Asset forfeiture claims are also civil cases. Then we have PIA, the Promotion of Access to Information Act. They can also end up in civil cases where you're asking the court to provide a certain type of redress. So often you'll have organizations or individuals approach the court and ask them for some form of redress. So can you allow a certain government department to provide documents or files based on of a certain matter that they are, or certain information that they're looking for? Can they be forced to provide those papers because they've not provided those papers before? Another difference between, so civil and criminal cases can be seen across our court system. So if we're looking at the little house that I was speaking about a little earlier, it doesn't mean that civil cases get seen by the higher courts and criminal cases get seen by the lower courts. Depending on the severity of cases, different cases go into different courts. So for example, a civil law case that can be seen at the magistrates court level, which is our lowest level of our court system, is a small claims court. So anything, if somebody owes you money or there's a contract dispute that is under 15,000 Rand, that will be seen at the magistrates court level. From a criminal court perspective, all crimes that fall into a certain section of our Criminal Procedures Act fall under magistrates court. In fact, the only criminal cases that go to a high court would be murder and rape. They go to trial at a high court because they're seen as more severe cases. Also, in terms of our monetary value, when you're going up on that ranking from magistrates courts, you then have regional courts deals with matters. They can impose fines of up to 600,000 Rand, sorry. So they deal with civil cases that are under 400,000 Rand. So, and in line with that, in the next step, the high courts deal with cases that are over 400,000 Rand. So anything higher than that. So even the case that we're seeing now, the criminal case with the former Gauteng Health MEC, Brian Shlongwa, it's currently being seen at the magistrates court because it was his first appearance. However, because it involves 1.2 billion Rand, it will go to the high court for prosecution. When it does go to prosecution, it cannot be dealt with by a lower court. And that's because a lower court cannot impose a sentence, such a significant sentence. They deal with lower sentences. They deal with smaller crimes. When it comes to high court crimes, your murders, your rapes, that's where high courts can impose stronger and longer and harsher sentences, and that's why they deal with those types of cases. So let's look at some of the big cases that we've seen in terms of civil law and in terms of criminal law. Jacob Zuma provides us with a lot of material in terms of civil law cases. I mentioned it a little bit earlier. Jacob Zuma went to the Constitutional Court where he tried to rescind his contempt of court judgment. At the same time, he was also in the High Court where he was asking the High Court to stay the execution of the contempt of court order until the Constitutional Court had made a ruling. Now, both those cases were civil cases, but they're happening in different courts at the same time. One was in the Pietermaritzburg High Court and the other one was in the Constitutional Court. And in fact, the Constitutional Court was a constitutional matter, so it was a civil matter and a constitutional matter. At the same time, Jacob Zuma was also involved in a criminal case in the High Court, and that's linked to his arms deal case, which is currently ongoing. But that's a different case, and that's also dealt with in the High Court because it's of a certain value. The Kolobeni community is also another example of a civil law case, and that's quite a significant case in line with what Dianne says, where it was a legal precedent was set. It was quite a significant case. The Kolobeni community in the Eastern Cape were given in fact, they asked, it was a PI application, they'd asked for details on the mining, a mining giant that wanted to mine in their area, and they wanted details of that, of how the mine was going to affect their area. And they were able to eventually, after a very long battle, it was a 6-year battle, they were able to get the details of the mining application. And what's very important is that the community, I just want to go to my notes, the community was able to get the court to argue, well, to rule that in any proposed, whenever there's any proposed mining activities, those mines have to give the details to the communities of how they're going to be affected. Now, that's very important because it also signals justice for more than just a single person. It signals justice for an entire community. It's important because it also means that they can use that case as a precedent going forward. Other communities that face similar cases can use the Kolobeni community case and argue that they deserve, if it's not, if they don't get those rights as the court has agreed, they can reference that case and get the same rights that community got. From a criminal law case, we look at two of the biggest cases. Well, one of the biggest cases that we've seen is the Oscar Pistorius case. Dianne references that was quite a significant case, but that's really a case that we see play out in the high court system for a long time, and it's now playing out in the judicial, in the legal system beyond the courts, because as you see now, he's applied for restorative justice. The Rosemary Ndlovu is another case that's playing out in the court. It's our cop that killed various family members so that she could claim on their life insurance policies that she had set up for them, but also another prominent example of criminal court cases that you do see. Now, as journalists, we report on various criminal cases and civil cases. And as we go through the system, through our webinar series, we will explain to you exactly what it is that you need to know. Particularly in webinar 2, we'll look at what is some of the things that you need to remember, some of the tips that you can remember when you are reporting on, for example, when you are at a high court, where do you get information? How do you retrieve the information? What are the processes that you go through? For now, we were literally just trying to give you an overview of what the different elements of criminal law and civil law are and how they interact with the legal system. The last element that I want to talk about is the role of the media when it comes to reporting on the courts. Now, this is probably the most important part of us, for us as journalists, and I'm going to invite Dianne onto the screen as well. The most important thing that I want to talk about, and I want to reference back to the Constitution, to the principle of open justice. The open justice is a principle in our Constitution that really talks to the value of accountability and the fact that the public should be able to scrutinize the courts. They should be able to be part of the court system. And when it comes to that, the media play a very important role in that matrix, if I can put it that way, in the sense that the media are often the people, and they have two roles. On the one hand, they are watchdogs, and they make sure that the court processes follow the right, that everything is fair in the court. And on the other side, we as the media play a very informative role. We educate the public. We tell them about what's happening in the court cases. We give them a blow-by-blow account. We're the first account of history, in a sense, by giving them a blow-by-blow account of how court processes have unfolded and what it means for them. And that's a very important role that we have to play, both the watchdog role and the informative, educative role that we play in terms of the media, and in terms of holding everybody to account and making sure that things are as they should be. Maybe we can have a question, Dianne. We can just ask our participants, in terms of the role of the media, what do they see as some of the challenges that you have in terms of being a media person that's reporting on the courts? Does anybody want to provide any answers? Does anybody have any comments in terms of the role of the media?
No, guys, for me, it's just the jargon, because obviously I didn't study law. So, it's the jargon that gets used that for me, I want to understand better. But so far, so good. Thanks.
And makes it complicated. I mean, the problem with jargon is that you're right. Some of us, Diane's been covering courts for a very long time, so she's very familiar with jargon, but some of us don't understand the jargon. I'm sure that the Reporting the Courts manual is going to help you significantly, because there's quite a significant amount of jargon that they unpack, acronyms and terms that you need to understand. And it does become complicated, I have to agree with you, because different courts use different types of systems. So in a lower court, it's a magistrate, whereas in a higher court, it's a judge. There's a difference already. So when you're reporting on it, it's important to remember that you're not referring to the judge or to the judge in a high court as a magistrate. So there are different elements. Are there any other questions, any other comments? The jargon can get.
Yeah, there's just a comment here from Mzwandile Kati saying the jargon sometimes makes things very complicated. And I think that's just something that we'll also note as far as the series is moving forward. With the second part of this, which is due to take place in January, that's where we will really focus on the courts and the different court hierarchy. And what we'll also do is just kind of unpack some of the jargon, just to simplify some of the key terms that we'll be taking out. So please keep in touch with SANEF and the IAJ. They will be posting additional information as to when that second webinar will take place. I think it's in January. I'm just not 100% sure of the actual date. And that's where we will really unpack everything relating to the jargon for the different courts, because I must say that is something that I also found quite confusing when I started reporting on courts.
I think I do see that we are out of time there, and so I do think there might be some final remarks from anybody. We did have a session to discuss now.
There was just another question here from, and I'm not sure if I'm saying I'm just going to say Eric, saying that he's a Swedish correspondent and he's been confused by the SA legal system. And I was just wondering, Eric, which aspects did you find most confusing when it comes to the SA legal system? If you could maybe elaborate on what was most confusing. And of course, we're here to help. So we want to see if we can answer whatever questions that you have, as the series actually unfolds.
Well, I'm an outsider. I'm quite used to reporting law, but when I come to South Africa, it's just a big mess about, especially the appeal system, I think. Is very confusing, and also the time frames involved in some cases that are not prioritized can be. I mean, you're mentioning Zuma all over again. I think Zuma has provided excellent educational material for generations to come, but especially for me, I'm really looking forward to this. I was just seeing, I think it was Dianne sending the link on the journal's WhatsApp group, and I've almost been waiting for something like this. So I just want to say I'm looking forward to the following installments. I hope I can follow the small course.
Oh, absolutely. So maybe I'll just do a quick, I mean, this won't answer you fully, and I really think the 27th, we'll make sure we also include the appeal aspect. I think the part that can be quite confusing is that you first apply for leave to appeal, and then you apply for then you actually continue with the appeal. And the leave to appeal process, I've noticed, is something that trips people up quite a lot, because you usually go to, especially if it's a high court matter, you go to the same judge who will have heard the case to apply for leave to appeal. So essentially you're asking for permission to appeal, and that judge will look at the facts and whatever the lawyers have put on the table to indicate whether there is a prospect of success in another court. Now, sometimes the lawyers do skip that process, especially if they don't think they'll have success, and they'll go straight to the Supreme Court of Appeal. And there are instances, especially where they can show that it's an urgent constitutional matter, that you can actually skip the Supreme Court of Appeal entirely and go directly to the Constitutional Court. But generally speaking, the process will be at a high court level, leave to appeal in the high court. Then if you're not happy there, you can go to the Supreme Court of Appeal. And then after that, you can go to the Constitutional Court, which is kind of the top of the house that Candice was speaking about. But we'll make sure that on the 27th of January, sorry, Faisal just put the date in the group, when we look at the details of navigating the court system, that we actually are able to focus on the jargon, as you've mentioned, as well as touching on the appeal system.
And Eric, just to add to what Dianne said, I think we'll also be developing some fact sheets and some infographics that will really help you, that will be able to sit on the SANEF website, that will accompany the report in the court's manual, that will really help you to have access to it going forward, where you can constantly reference it. You don't have to download it onto your computer and have it there all the time, but you would be able to reference it and just, you know, use it as a reference sheet and go back to it and check things. And I think that will be helpful for all journalists, not just for ones who are not from our country. You know, often sometimes you miss processes, or you're not sure of processes. It would be helpful to have that there, just to use it as a check and a reference guide. To Liesel's question, will material be made available that we can read ahead of the next webinar to better prepare? That's a good note to make, Liesel. Maybe we should give you a few, well, once the portal is established, we might be able to set up some material on the portal that will give you a bit of an idea as to what we will be discussing and how we can go forward. But do keep in touch with us, keep checking the IAJ's website and SANEF website, and I'm sure that when the portal is developed and when the next webinar is starting to be advertised, we can start engagement and discussion around that. So,
yeah, I think this would also be an opportune time for Hopewell to maybe just come in and just tell the attendees just a little bit about the thinking around the portal, and when they are able to actually, when they are likely to be able to actually access it, because the portal will be the kind of longer living place where we'll place the videos from the webinars, materials, as well as the actual book that was developed. So Hopewell, if you're still with us, if you can just give us some a bit more information on the portal and when the delegates are likely to be able to see that come to life.
Hi, I hope you can hear me.
we can.
Dianne?
We can.
Yes, certainly, Hopewell, we can.
Okay. Thank you very much, guys, and thank you for such an excellent presentations that you've made and the questions from the participants. As SANEF, we are going to, in fact, it's in the process right now. We will be test driving it in January, the pilot, what you call the portal, that is, where all the information that Candice talks about will be in there, starting from the what you call revised manual by Gwen. So as soon as it is up, we will be sending lots of tweets maybe and everything like that, inviting people to also look at it, and we will appreciate the input if people feel that it will be covering everything, because it will be something that is, we mean to see it being alive. We'll be able to update it if people critique it and want to see it evolving and maybe made better. It took us 10 years to get the first manual to the second manual. And what Gwen has asked SANEF to look at is that we don't make it static. We make sure that we find a way to have it updated better and regularly than we did. Most of the laws, as you heard Candice and Dianne saying, that we're evolving, we're changing, and some of the rulings have changed the dynamics of the legal system. So we want to see that happening as soon as something up comes, and then we find a way to update it. So we'll be talking to people to put it that way. We also plan to find a way to sort of print this, with the reason that there's not a big budget to do the print and make the thousands of copies like we did before. And people kind of feel that maybe if it's alive on and downloadable, people can then do that using their phones and so on. And we intend to make sure that if you want just a certain chapter, you can then download that particular chapter and be able to read and go through what's happening. It's been reviewed and revised by legal people. We also had the fortune of getting people like Justice Cameroon, looking at some of the chapters, particularly the constitutional aspects that you talked about. Both of you did touch on that. So it has been looked at by really the greatest minds of our system, people who have been instrumental in making judgments that have changed the course of law in our country. So we will be doing that, putting it up. From January, we should be able to test pilot it. So thank you so much for for all this. Thank you.
Oh, well, thank you so much for the explanation and the engagement. And I think we all look forward to the portal. And I think it is going to be a very helpful tool for journalists, not only those who report on the courts, but all journalists. Thank you so much, guys. Thank you very much for joining us today for our first session, Understanding the Legal System. I think that's the end of our session. Thank you.
Thank you. Thank you.
Thank you for everyone attending. And just a note, the 27th of January, put that in your calendar. We'll be sending out an additional flyer, but you can note it in the meantime for the next session. And hopefully that one will be attended. And we also hope for some great, robust discussions. So bring your questions, have them ready. We've noted some of the questions you have already. And that one will be focusing more specifically on navigating the court system. Thank you.
Thank you. Bye.
Thank
Bye-bye.
you. Thank you. Bye.